Welcome back, everybody. This is going to be my third video, as only a handful of you are going to be aware anyway. Obviously, we left off last time getting ready to discuss, we discussed good behavior and what that meant. And right now we're going to be covering, like I said last time, the term of art called, which is high crimes and misdemeanors. Now, granted, this phrase is only used once in the Constitution, and that is solely in Article 2, which concerns the executive branch, but the clause itself says that this phrase, used for impeachment purposes, refers to all civil officers of the United States. However, a question that is commonly asked about this phrase must be addressed first. It is, why not simply crimes and misdemeanors? What's high mean, specifically? Well, Blexton answered this, albeit somewhat indirectly, in his discussion on treason. He said, quote, "Treason, proditio, in its very name, which is borrowed from the French, imports a betraying, treachery, or breach of faith. Breaches of the lower allegiance, or private and domestic faith, are denominated petty treasons. But when disloyalty so rears its crest as to attack even majesty itself, it is called by way of eminent distinction high treason, or alta proditio." End quote. That's taken from Volume 4 of his Commentaries on the Laws of England, the fourth book instead of Public Wrongs. It becomes clear from that excerpt that what differentiates any given crime from a high crime is the position of the person or persons against whom the crime is committed. Thus, a high crime is one committed against the sovereign or the state. Keeping this in mind, of course, the fourth volume of Blexton's Commentaries began by defining the second part of the term being considered, that is, crimes and misdemeanors. He said that the final book in his work, quote, "treats of public wrongs or crimes and misdemeanors," end quote. Therefore, if the inquiry ended there, then the definition of high crimes and misdemeanors would be as follows: public wrongs which are committed against the state and or affect how it functions. End quote. That's just me positing what we could draw from that excerpt there. However, Blexton had a lot more to contribute. He said, quote, "A crime or misdemeanor is an act committed or omitted in violation of a public law, either forbidding or commanding it. This general definition comprehends both crimes and misdemeanors, which, properly speaking, are mere synonymous terms. Though in common usage the word crimes is made to denote such offenses as are of a deeper and more atrocious dye, while smaller faults and omissions of less consequence are comprised under the gentler name of misdemeanors only." End quote. Now, from this we can draw certain conclusions, the first of which is that the word high only modifies the word crimes in the phrase under scrutiny, because otherwise it would be sort of redundant, high crimes and high misdemeanors. It doesn't make sense. Second, in the context of the Constitution, this makes it plain that our civil officers can be impeached for things other than serious offenses. But what sorts of things can fall under the category of misdemeanors? Blexton himself was not overly explicit on this account, and so we have to consult another respected source. One can turn to Joseph Story, once again, who wrote in his commentaries, quote, "The offenses to which the power of impeachment has been and is ordinarily applied as a remedy are of a political character. Not but that crimes of a strictly legal character fall within the scope of the power, but that it has a more enlarged operation and reaches what are aptly named political offenses, growing out of personal misconduct or gross neglect or usurpation or habitual disregard of the public interests in the discharge of the duties of political office." End quote. That's taken from Volume 2 of his Commentaries on the Constitution of the United States. So in this respect, the term of art high crimes and misdemeanors can be tied into the definition and implications of disorderly or good behavior, like we discussed before. For instance, and this is, I don't know, purely hypothetical, if a president were to be caught having intercourse with an intern on the floor of the Oval Office, which is not a private room, but rather a room in a federal building, that alone would be grounds for impeachment. Or say he blames a YouTube video for the death of some of our men and women overseas, including an ambassador in a place like, I don't know, Benghazi. Now, in a sense, misdemeanors can be understood to mean bad behavior. High crimes and misdemeanors. Misdemeanors in this sense would mean bad behavior. A political officer can be impeached and, if convicted, removed from his post if the charges are for a high crime, which means he has done damage to or struck against the sovereignty of the United States. Remember, the sovereign of the United States is the Constitution, not any given person in the government. Misdemeanor would mean more or less bad behavior or those things unbecoming of a person in such an office. Now you can see, I hope to incorporate more of what I'm talking about in these videos to more to things that are more relatable to the common everyday execution of government, because obviously there are some things that no longer apply anymore because the time has passed for it, or it just may seem like I'm just rambling about a particular thing. But as we go along, get into the terms of art which can apply more to our everyday experience of government, and not just something that's sort of intellectual and beard stroking. Oh yeah, it's very interesting. No, I hope that this will become more obvious as time goes on. And speaking of which, I can gladly say now we are approaching the final term of art among the more general ones to be found in the Constitution, is privileges and immunities. This term is only found once in the Constitution, Article 4, Section 2, and to be sure, it is one of the most ambiguous. The phrase is written in the context as follows. I'm taking this directly from the Constitution. Quote, "The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states." End quote. First, we have to note that the several states may be an error on the part of the founders, or at the very least, of the Committee of Styles headed by Governor Morris. It could, in fact, in good faith, be construed so as to reference foreign states, such as France, Austria, etc. However, given that such a meaning or an understanding would make things incredibly complicated and even more difficult to define or limit, it is far more likely that this refers to the remaining respective states other than the first state mentioned in the clause, i.e. the citizens of each state. Meaning that, I'm trying to say that this will apply to citizens of every state, including this one that we're singling out, and then all the other ones that happen to be a part of the Union at the time. I can't proceed just so far yet, because it would be best to consult Blackstone on the matter first, once more. He wrote that, quote, "Rights themselves are thus defined by several statutes and consist in a number of private immunities, which will appear to be indeed no other than either that residuum of natural liberty, which is not required by the laws of society to be sacrificed to public convenience, or else those civil privileges which society hath engaged to provide in lieu of the natural liberties so given up by individuals." End quote. And that's taken from his first volume of his commentaries. It would seem that Blackstone himself understood that there may be more than one potential source for these respective privileges or immunities, both of which are mentioned. He seems to imply that all men are born with certain rights by natural law, which again comes from God's design, as he elaborates upon in the pages following the above cited text. In the previously mentioned text, again, by all means, feel free to go and rent a copy or buy a copy of his commentaries to follow along with me, because these things are in fact very important to understanding the context of what's being read or written. You notice that what remains or is left over after members of society sacrifice some of their rights to public convenience, as he says, is what is meant by private immunities. The latter half of the excerpt provides a second potential source of said immunities, this time mentioning explicitly the term privileges. It would appear that immunities are, as supplements to men's natural rights, those civil liberties conferred upon men by the state's natural authority to govern and protect the society entrusted to its care. although somewhat confusing, this definition makes sense if studied slowly and methodically. Now, I probably should just slow that down and rework it one more time. It's just that privileges and immunities is sort of, again, it was one of the most ambiguous of the terms of art used in the Constitution, but essentially it just takes for granted that there are rights that are granted to us by God, that is the natural law, and there are also, that's essentially what we would call the I guess you could just say natural rights: life, liberty, pursuit of happiness, right to own property that you've worked for, etc. But then we also have something, a different set of rights or privileges and immunities, which come from the civil authority. Even something as simple as voting. People think, well, no, voting is something that you are granted by virtue of being an American. Then that's not necessarily true. We have the natural and civil side of rights. We have like a dividing line here. You have that which is granted to us just by nature of our being born, and those things that we have inherent in us as human rights and having such inherent dignity. And then there are those things which are granted or simply protected by the state. And in the civil sense, they are granted by the state. Like, for instance, convicted felons cannot vote. Whether or not people don't agree with that is neither here nor there. I'm just getting to the point. I'm just making a point that it is in fact a privilege that the state imbues us with, and so long as we're responsible and act in such a way as is either helpful or at the very least neutral toward the existence of the state, we can retain it. It is something that can be taken away by government. That is essentially the deciding line. Is if it's a natural right, it can't be taken away from you. It's something that is fixed, solid, done deal, because God put it there, and, well, we'll be damned if the government's going to take it away from me. The civil side of rights are ones that the state can, in fact, either bestow or revoke, assuming that it exercises good judgment. So hopefully that clears up any of the confusion that may have been left behind. But now all that really remains is to discern how the definition of, all the information that we've gathered on this particular term of art, privileges and immunities, is to discern how this factors into an interpretation of that phrase. Still, it might be better suited. We might be better suited to do so if we were to study at least one or two works on the issue by men who actually attended the Constitutional Convention that gave birth to the Constitution itself in 1787. It must be noted, however, that when it comes to privileges and immunities, almost no such literature exists. Very, very little. Luckily, it is at least mentioned in passing in Federalist number 42, which was written by none other than James Madison, who is colloquially known as the father of the Constitution. In this work, he references the Articles of Confederation, that is, the governing document for America prior to our current Constitution being implemented. And from the Articles of Confederation, in the Articles, there was contained language very similar to that which is used in the Privileges and Immunities Clause. Sorry. He wrote that, and this is the excerpt I'm taking from Federalist 42. In the fourth article of the Confederation, it is declared that the free inhabitants of each of these states, paupers, vagabonds, and fugitives from justice excepted, shall be entitled to all privileges and immunities of free citizens in the several states, and the people of each state shall, in every other, enjoy all the privileges of trade and commerce, etc. There is a confusion of language here, which is remarkable. Again, he is just quoting the Articles of Confederation and speaking about those. Why the terms free inhabitants are used in one part of the article, free citizens in another, and people in another, or what is meant by superadding, quote, to all privileges and immunities of free citizens, end quote, all the privileges of trade and commerce, etc., cannot be easily determined. It seems to be a construction scarcely avoidable, however, that those who come under the denomination of free inhabitants of a state, although not citizens of such state, are entitled in every other state to all privileges of free citizens of the latter. That is, to greater privileges than they would be entitled to in their own state, so that it may be in the power of a particular state, or rather every state is laid under a necessity, not only to confer the rights of citizenship in other states upon any whom it may admit to such rights within itself, but upon any whom it may allow to become inhabitants within its jurisdiction." Close quote. Now, that's a very wordy, very complicated. I'm going to try and break it down for you. Even I panicked a little bit when I first saw it. I'm like, But first we can narrow down what's useful in this passage by remembering that the Privileges and Immunities Clause of the Constitution pertains to citizens only. What one can garner from Madison's writing is minimal yet helpful. It reveals that the clause under scrutiny more than likely is a provision which pertains to individual states' treatment of citizens of the United States as a political whole when they enter into one state from another. There's an excerpt from a work written by a man named C. Herman Pritchett, Pritchett, and it was titled simply "The American Constitution," where he summed up relatively nicely what I think has been uncovered thus far, saying that the interpretation, quote, which was in fact probably the one intended by the framers, was that the language be read as meaning simply that a citizen of one state going into another state is not to be discriminated against because of his out-of-state origin. There is no need to search for any natural law or fundamental standards. The privileges and immunities to which an individual is entitled are those which are standard in that state, applied without discrimination. Under this view, the clause is read as though it said, "The citizens of each state shall be entitled in each of the other states to all privileges and immunities of the citizens of the state in which they shall happen to be." Close quote. Logic seems to dictate that this is most likely the interpretation of the most likely interpretation of the clause. However, there may be an item or two which needs clarification. This mostly concerns Pritchett's statement here that there is no need to search for any natural law or fundamental standards. In light of what Blexton wrote, this may not be the case, at least not entirely. Pritchett's comment indirectly refers to the infamous, well, I shouldn't say infamous, it was a pretty big case. It was the 1823 Corfield versus Coryell case, which is actually explicitly mentioned in a portion omitted from the above citation that I gave. I had to condense it a little because it went on for a while. But in the case that I just mentioned, Corfield versus Coryell, Justice Washington wrote that Article 4, Section 2 protects privileges and immunities which are in their nature fundamental, which belong of right to the citizens of all free governments. And then he proceeded to list a very long series of activities and rights which could fit into that suggested definition. Theoretically, arguments could be made for a sheer multitude of potential rights which could fit under the protection of that clause in question. And obviously, even from this standpoint alone, it makes Justice Washington's opinion not only problematic, but almost certainly entirely incorrect. Because no two people will ever agree on a completely identical set of rights that could be considered the privileges and immunities referenced. So how likely is it that large communities such as states would do so? It doesn't seem to make a whole lot of sense. In this respect, Pritchett was right to reject Washington's theory, which, to be sure, was not the holding of the case, but mere obiter dicta, or spoken word, and its suggestion that the clause encompasses myriad lofty fundamental rights. That, again, it does not seem to be the case that a series of very specific things was mentioned underneath it, but again, is a slightly more general term. However, when Pritchett says that there is no need to search for any natural law or fundamental standards when defining privileges and immunities, he may have gone a bit too far. As established earlier, the natural law is a major foundation for the rest of the English and subsequently American common law, as Blexton confirmed. Besides, Pritchett's substitute interpretation of the Privileges and Immunities Clause, the one that he mentioned in the excerpt that I took, that the citizens of each state shall be entitled in each of the other states to all privileges and immunities of the citizens of the state in which they shall happen to be, seems to have left the term privileges and immunities itself still undefined. A potential definition, since a concrete one is pretty much entirely absent, in line with the natural law theory outlined in Blexton, could be, and I'm conjecturing, but this is what I'm thinking I can ascertain from these, would be, quote, the irreducible minimum of qualities necessary for consistency with the human dignity of citizens, close quote. Another definition, one more in line with the civil rights side of the Blextonian formulation. Remember, natural rights, civil rights. This is more in line with the civil side. Again, this is me conjecturing. It could be simply those things that the law declares to be privileges or immunities. That is, those things that it declares that a citizen of a state may do or be protected from having to do. And that's, again, because this is one of the most ambiguous terms within the Constitution, that does in fact seem to be the best that we can get from it. And while not entirely helpful, it at least doesn't make it as much of an eyesore just standing there waiting to be defined or elaborated upon. So with that, a historical and legal overview of the more notable terms and general terms of art in the Constitution is pretty much now completed. And we can now proceed to examine those terms which are specific to either only one branch of government or those terms of art which are in fact more widely known and spoken of. I would hope that this has also been helpful. I do wish I wish to apologize in case this one seems kind of lofty, but having a more welcome availability of knowledge about the more general terms will eventually help us out later on. But since, and I wanted to apologize to people and say that it did in fact seem lofty, but I am in fact going somewhere with this at some point. So with that, I would like to pick up next time with terms of art that pertain solely to one branch of government, such as legislative powers, executive powers, and judicial power. And then we'll go on from there. So again, I thank everybody for joining me, and I hope to see you next time. And from here on out, I will try to put all of my new videos online on Thursdays, preferably later in the evening. So if you are in fact following along, please feel free to join me next time, and I will try to upload a new video on Thursday night. Okay, thank you very much, everybody. I'll see you next time. Bye-bye.